Why will the matter not be heard on merits? This court is not hearing the matter on merits. For the last 10 years, the appeal is pending. And now it is being dismissed
For their cause, my lord. This
for their cause
in the year
against this
2014
order.
against this order. Now, my lord, since 2014, my appeal has not been heard. My lord, during the pendency of the appeals, the added respondents made an application for addition of party. They said we are the owners, so we should be added as the party in the writ petition in the appeal. Now, the person responsible was the developer. There was he was authorized. He was authorized. He was present during the course of hearing, and he was the person responsible. Still, my lord, in the year 2014, but the appeal was papered and the owners were added as parties. Now, my lord, the matter came up for final hearing on 5th December 2022 when the learned advocate appearing for the private respondent said that one of the owners, Aurobindo Roy, had died. Now, my lord, the petitioner is not aware as to who are the legal representative, legal heirs of this Aurobindo Roy. But in spite of request, the learned advocate appearing for the private respondent did not give any particulars. Then, my lord, I had to take out an application before the learned tribunal praying that the appeal may be heard in the absence of the dead person. His name may be expunged from the appeal cause title. Now, my lord, that was rejected. Against that, I came up before your lordship. My lord, your lordship was pleased kind enough to pass the order in January 2023, directing the learned tribunal to consider the case of the petitioner so far as the appeal could proceed again without the dead person, and there was direction by your lordship upon the learned tribunal that the appeal should be disposed of by the 22nd December 2023. Now, my lord, I had since, my lord, the same thing happened. My lord, the learned advocate appearing for the petition did not provide any particulars of the legal heirs. My lord, the petitioner before your lordship, my lord, had taken out another application asking before the learned tribunal to proceed with the appeal and expunging the name of the Aurobindo Roy. Now, my lord, that application was again rejected, and my lord, by the final order, which I am challenging all the orders, the learned tribunal has dismissed the entire appeal itself
On the ground?
on the ground that I did not take steps. My lord, my application was dismissed on 6th December at page 113.
113.
Yes. Internal page 4 of the
6th of December 23. Who is the developer person responsible? Is 4.
respondent number 4.
my lord, my respectful submission before your lordship. First, your lordship can consider the
There is no issue of locus standi in respect of unauthorized construction matters.
second issue is this, my lord, the lordship can be come for a moment to page 66.
Why will the matter not be heard on merits? This court is not hearing the matter on merits. For the last 10 years, the appeal is pending. And now it is being dismissed
For their cause, my lord. This
for their cause.
Kindly come
My
page
lord.
119. Kindly come page 11.
Who is the heir of the deceased Aurobindo?
body knows, my lord.
Nobody knows.
But
Who was
here
Aurobindo?
that the relatives they say don't know.
Very well. If nobody knows, let his name be expunged. Let the matter be decided on merits.
My lord, his name was included by order 1.
Yes.
So somebody came in for him.
No, they themselves.
Order 1, Rule 10, application for addition. That means somebody applied for him to make him added as party.
He himself.
Now he has died. Let him be expunged.
My lord, the petitioner has knowledge because your lordship can come for a moment. 2 lines I will show to your lordship, page 66.
Assuming the petitioner has knowledge. Assuming. Since nobody is coming up, why will his name not be expunged and the matter be dealt with on merits?
So far my understanding is concerned, my lord, the pleading tribunal, appellate tribunal has dismissed the appeal on the ground that without expunging or substitution of the name of the deceased as alleged to have been died, the proceeding cannot be continued.
Yes.
This is the only ground.
If that be so, let his name be expunged and the matter be decided on merits.
The tribunal is absolutely wrong on that score. Under Order 22, Rule 4, Sub Rule 4, there is provision for exemption of if the cannot be substituted, there is provision for exemption. So that the appearance of that person or their legal heirs can be exempted if the tribunal deems fit. But that aspect has not been considered. The tribunal should decide the matter on merit.
Yes.
Without deciding matter on merit, on
Technical
technical
issues.
reason, they have dismissed. That is
And the
absolutely.
last 10 years, the
not
matter
workable.
is pending. Just imagine.
Well, I am the precedent, in a matter division bench directed the tribunal to dispose the matter within 15 days. They have done.
They have
Yes,
done that.
Yes, kindly direct that.
My lord,
But within
Kindly
15
come
days
to-
has to be disposed of on merits.
This is exactly the challenge as to how it could have been regularized.
perhaps that is not under.
What is the
I'm
matter
challenge-
pending?
I am challenging this order passed by the special officer
What
building
is
itself.
under challenge
If
before
this
the
order
tribunal?
goes,
Initially, the challenge was the unauthorized construction. Now, once it is detected by the petitioner and reported to the corporation, my lord, subsequently the corporation allowed the petitioner to regularize the unauthorized alleged unauthorized construction.
And that order is appealable.
That has not been happening.
Which one is that?
SOB order is under challenge. If this order goes, everything will go.
Lordship, kindly come page 190.
Yes.
The appeal has a checkered history.
Don't read. Tell me what is there. Don't read.
Lordship, kindly come middle portion.
Yes.
Applicant without complying the direction of the Honorable High Court. Lordship, got it?
Yes.
High Court filed a petition for expunging the name of the Anirban Roy, who has
Aurobindo Roy.
been added. So Aurobindo Roy, who has been added as a party to this appeal as per the direction of the Honorable High Court, Calcutta. Appellant has not availed the provisions given in the civil procedure code for making substitution the death of the resident number 4, Aurobindo Roy. The matter has been raised before the Honorable High Court, Calcutta further, and the Honorable High Court, Calcutta on 28 June 2023 in WPO such and such directed this appellant to proceed with this appeal and also directed in such circumstances it will be open to the tribunal to take a decision as to whether the appeal can be proceeded in the absence of the owners as their interest is being duly protected by the developer who has an agreement with the owners of the development of the subject property. This appellant mysteriously, without taking the opportunity given by the Honorable High Court, Calcutta, has filed another mysterious petition by way of the submitting that the appeal may be heard in absentia of the heirs of the deceased respondent number 4, Aurobindo Roy, and that
Tell me what you want to show from here.
he has not complied the order of the
What is to be
Honorable High Court.
complied? What is to be complied?
Substitution application.
Give the details of the heirs.
And the petition was.
Who are you?
Lordship, I am the owners of the other flat owners who has been, Lordship, the.
Flat owners,
Flat
not the original owners of the property. You are the flat owners, subsequent purchasers.
No, these are the persons who had preferred that order 1 rule 10 application. They themselves got added in the appeal. They are the owners.
They should know the name and name.
They are the owners.
If my flat is demolished, Lordship, I will be affected parties.
That means you are the subsequent purchaser of the flats, which have been which has been regularized.
They are the owners. They are the owners.
owners.
Original owners.
Original owners.
They had preferred that application under order 1 rule 10. They themselves got added in the appeal.
So you are the original owners. You must be knowing who is the heir of Aurobindo Roy. You are deliberately not disclosing the heirs.
I don't know, Lordship, because till date, Lordship,
You-
kindly direct the petitioner to show any single document that by way of a document, Lordship, he has asked for the heirs, name of the heirs of Aurobindo Roy. Lordship, kindly, it has been, Lordship, the not.
If you want to try to take this type of technical points, then you stand at a very weak footing. This the court can understand.
Under order 22, it is the duty of the defendants when one defendant
Yes,
dies.
to inform the court.
Yeah, the lawyer to inform the court and also to. the
As regards
plaintiff,
the death,
As regards the.
So far, the person who expired, Lordship, maybe he's a Lordship co-owner, but Lordship, I am not related. So I don't.
you are not related.
No, Lordship, I don't know who are the heirs.
You, along with the dead person, filed application for being added as party.
When the added, this person was added, was alive, subsequently expired. That is, That is not the case.
Please make rational submission. A person who has died could not have come up with an application for addition.
Page 56.
Right?
Kindly-
Obviously, it is when he was alive that the application was made. Don't make rubbish submission before the court. Right?
Application page 56. Madam, kindly come.
Lordship, can you take that page 55 first? Page 55. Lordship will see the name of the learned advocate who is appearing for this is the advocate who is appearing for the developers also. And this is the advocate who has filed his application order 1 rule 10. Lordship kindly comes to next page, page 56. Application under order 1 rule 10, read with section 151. The humble petitioner on behalf of Aurobindo Rai, Krishna
Aurobindo,
Rai,
Krishna,
everybody.
Krishna, everybody.
everybody.
Same person.
Same person.
And you do not know anything.
Well, for the 10 years, this thing is happening. Tribunal is not asking the learned advocate to provide the details, and I am being moved in a whirlwind in the tribunal.
You are Krishna, Trishna, Shubhashit and everybody.
Everybody.
It is you who is
Everybody.
representing them. You must be knowing how you added Aurobindo with you. Your petitioners are the co-owners. That means you are deliberately not disclosing the name of the heir of the deceased.
Kindly.
No, without going through the brief, you simply came and said that it is technical and it should be dismissed. Please come.
Kindly come with some time. Lordship.
No, no. Enough time has been granted. More than 10 years have passed. From the documents annexed to the writ petition. The কি বললাম? From the documents annexed to the writ petition, it appears that an application for addition of party